My name is Gill Whitfield and I'm a patent attorney with Astrum IP Limited. My presentation today is going to discuss intellectual property, why it's relevant and how it might help you with your projects. So the first question is, what is intellectual property and why should you bother to protect it? So intellectual property is a commercial tool that's used by companies to help protect their innovations. During this presentation, we'll discuss the various different types of intellectual property, but to begin with, what I'd like to do is show you a couple of everyday objects and point out the various forms of IP protection that are relevant to those particular products, just to illustrate the purpose of intellectual property and how it is present in almost every product in society. So the first product I'd like to discuss is a £10 note. This is obviously an old £10 note, but even with the new ones, there will be various aspects of intellectual property throughout the note. So to begin with, the fabric of the modern notes that supposedly can be put through the washing machine, that will be a patented process to produce that material. There will be a metallic thread through the note itself. Again, the method of putting that piece of foil through the fabric will have originally been patent protected. If there's a watermark on the note, then again the process of putting that into the fabric of the note will be patent protected. If there's a hologram in the note, again that will be patent protected. And any UV features that allow aspects of the note to be visible when put under UV light will also be patent protected. Now, there's every chance that these technologies, the patents have expired many years ago, but the fact remains that patents were important at the point of conception of the innovation. There are other aspects to the note that have intellectual property protection as well. So we have the Bank of England logo at the top of the note. That is trademark protected. Now, the Bank of England is such a large organisation and has such a large reputation that, in fact, that particular trademark isn't registered, but most companies will have their company name or their branding registered as a trademark in the relevant countries in which they have commercial interests. And finally, there is copyright. So there is copyright in the Queen's portrait, and although many people believe that the Queen owns that copyright, in fact she does not. Copyright belongs to the author, so in this case it would be the commissioned portrait artist. And finally, there will be copyright in the overall layout and look of the note itself. Moving on to the humble can of Coca-Cola, the ring pull shown on the left of the slide is the original style of ring pull, and this was invented by a gentleman in Ohio in 1962. In 1963 he got a granted US patent, and only 17 years later he was making over $500 million a year simply by manufacturing and supplying cans incorporating his special ring pull design. And the innovative feature of the ring pull was that he had managed to devise a method of putting a rivet into the can to hold the ring pull in place without compromising the integrity of the contents. Now, over the years, the ring pull has been redesigned, and nowadays the ring pull cannot be completely detached from the can during use, and again this newly designed ring pull is also patented. So you don't have to create something from scratch to get valuable patented protection. You can build on the innovations of others, and that is one of the foundations of the patent system. So moving on, there are also trademarks in the can of Coca-Cola. So the very famous Coca-Cola branding is registered both as a text mark and as a logo, and the Coca-Cola company have over 100 trademark registrations in the UK alone, simply to cover the evolving brand and look of their product marketing. There is also design right protection, so designs cover the outward appearance of an object, and in the case of the can of Coca-Cola, The contours of the can itself may also be protected by registered designs. In addition, the shape of the ring pull may be protected by registered designs. Although it's not the full object, you can protect a small part of an object in most territories in the world. There is also copyright in the pattern applied to the exterior of the can. So this will belong to the graphic designers that created it, unless of course, which is no doubt the case with Coca-Cola, the author of that copyright has assigned their rights in the layout to the Coca-Cola company themselves. And finally, there's a form of intellectual property protection that is not registered anywhere, and that is trade secrets. And this is where an innovation is kept secret by a company in order to prevent copying. The trade secret is extremely valuable, but only for as long as it remains confidential. So companies that rely on trade secrets, such as for the formulation of a drink, go to great lengths to make sure that very few, if any, employees know the full formulation details. And here's another everyday object that you will all be familiar with. You may not be familiar with this particular model of iPhone. It is one of the original ones. I'm showing my age now. However, modern iPhones have exactly the same intellectual property associated with them. So there will be patents in the technology within the phone. So that includes the wireless communications and telecoms software, the speech coding, the security, and any encryption software within the phone. There will also be trademarks. For example, if you look at the middle image of the back of the iPhone, the Apple icon will be protected, and the iPhone text mark itself will also be protected with registered trademarks. And Apple Incorporated own many hundreds of trademark registrations throughout the world. Then we have design right. So as I said before, design right protects the outward appearance of an object, and in this case it's the iconic shape of the phone. This is important to Apple as the look of the phone is what makes it desirable, as well as how it works. There's also going to be registered design right in the shape of many of the accessories, so earbuds, chargers, and protective phone casings. And then finally, we have copyright. So every single icon on the phone associated with each of the apps will have its own copyright associated with its appearance. Every screen layout within the apps will have its own copyright. And finally, even things like the whoosh sound when the emails are sent, the clicking sound when numbers are input, and even the shutter sound when the camera is used will be protected by copyright. So as you can see, intellectual property rights are extremely important, and as this quote sets out, most investors, when investing in high-tech companies with significant levels of funding required, will not want to put their money into the companies unless the business has already established an intellectual property strategy. Now that strategy may be to protect everything, or it may be to keep things as trade secrets if there are good reasons to do it that way. However, providing an intellectual property strategy that's well thought through can be demonstrated. Usually this is enough to satisfy investors. So let's discuss what is involved with patent protection. This slide sets out what you'll see as a standard definition in most textbooks, saying that it's a legal monopoly that gives the owner an exclusive right to do various things in relation to the invention within a given territory. It's not a bad definition, but it's not completely accurate. So a patent doesn't give you an automatic monopoly right to do things with your invention. What it actually does is give you the right to prevent other people from doing those things with your invention. So for example, if you have a design for a handgun, simply obtaining a patent to that handgun does not give you the right to make, sell, import, or otherwise use the handgun. You will have to go through other regulatory hoops in order to do that. However, it does give you the right to stop someone else doing that with your design of handgun. So just be careful there about the differences in the definition. It's subtle, but it is very important. So there are 3 requirements for patent protection. The first one is that the invention itself must be novel. And by novel, that's simply an assessment on whether it's identical to something that's already been done before, or whether it is different. And that difference could be very small or very large. But as long as there is a difference, you have established novelty. The second requirement is inventive step. This is a more difficult one. So this is judged by using a fictitious person who has a complete knowledge of everything that's ever been done in a particular technology area, but has absolutely no creativity. And the test is, would that person, when faced with the invention, understand how to arrive at it without exercising any inventive step? So for example, if you have a frame for a bicycle that is fluorescent in the dark, and that is caused by you simply coating the bicycle frame in a fluorescent paint, it would be argued that the skilled person would know that fluorescent paint existed, and they would know that bicycle frames existed, and they would know that to solve a problem of seeing something in the dark, you could apply the paint to an object. So simply providing a frame for a bicycle with fluorescent properties would not be considered inventive enough. However, if you invented something that you could coat on the frame of a bicycle that would make it glow in the dark only when required and was powered by the moon, then possibly that might be inventive. And finally, there is the requirement that it's capable of industrial application. And usually this simply means, can you manufacture it? Can it be used in commercial production? There are certain exclusions to this, and these cover things like, in Europe, methods of medical treatment, but it also covers other things like knitting patterns, maps, and various products that have protection in other ways in the intellectual property system. Okay, the pitfalls. There are many pitfalls with patent protection, and they are even more important when you're working in a university setting or a startup company setting. One of the first ones is ownership. So everyone is very happy and collaborative at the start of a project. However, when commercialization takes place and money starts to come in, everyone starts to get a little bit greedy and think that their contribution is worth more of the reward. So it's very important that if you're collaborating with others, you establish right from the start, before the innovation is made, who will own what. So for example, if you're working in a university collaboration with someone from a different university, it's very important that before the project begins, you've established who will own the intellectual property and what shares will be allocated to each participant once the invention is commercialized. Similarly, if you are working in a startup company and you employ contractors, it's important to remember that a contractor isn't an employee, therefore whatever a contractor does will not necessarily belong to the company, even if you pay the contractor. Therefore, it's very important to have the right contracts in place before you begin work that will allow the employing company to assert ownership over anything that's invented by the contractor during the course of that contract. Without this, you could reach the stage where your invention is very successful, you're making a lot of money, and then a contractor pops up and says that they own at least half of it, and it can cost companies a lot of money to fight this kind of argument in court. Okay, the second issue is good lab practice. It's very important that you can establish that you have done things properly, that you're entitled to the invention in case there's a dispute, and that you can account for every day in a lab book, ideally paper and pen. I know that's very old-fashioned now. Each page needs to be dated and numbered, and ideally, periodically, perhaps every week or two, it should be signed by an independent person who understands what's being done in the project but is not participating in the project themselves. And it sounds very tedious, but this is something that is carried out by large pharmaceuticals in their labs even today. Another pitfall is failure to check literature regularly. When companies are manufacturing and inventing products, for example, a pharmaceutical vaccine, they will prevent their employees from publishing in the traditional scientific journals until such time as the patent application publishes. And patent applications don't publish until 18 months after they have been filed. So you could find that the very first indication of what a company is working on occurs when the patent application is published. If you don't keep checking the patent literature every month or two at a very minimum, you might find that whatever you're working on has already been invented by someone else. Or you might find that you've encountered a difficulty during your research that you're having problems overcoming, but by checking the patent literature you might discover that someone else has already found a way around that particular problem. So keep checking the patent literature before you undertake any project, and please make sure that you keep checking it throughout the course of that project. And finally, ensure confidentiality, and this cannot be stressed enough. It's very important that any innovation is kept confidential until the patent application has been filed. This is because failure to do so means that your public declaration of your invention, whether it's published or presented even at a conference, could act as prior art against your patent application, thereby rendering it not novel and meaning that your patent protection isn't valid. So please do not publicly disclose your invention before you file the patent application. If you really have to disclose your invention, for example to investors, then make sure that they sign a confidentiality agreement before you have that discussion, because at that point they're bound by contract to keep whatever you tell them confidential, and it will not invalidate your patent protection. Okay, so just to emphasise, like I didn't emphasise it enough in the last slide, please do not disclose your invention prior to filing a patent application. And public disclosure is a very peculiar beast in legal circles. So for example, if you disclose your invention to a lecture room of 2,000 people, but every single one of those people has signed a confidentiality agreement, then that is not considered to be public disclosure. However, if you were to write your invention down, put it inside a library book, put that book back on the shelf in a library, film that book for the course of a week, and prove that not one single person pulled that book out and looked to see your invention, it is still considered public disclosure because it was available to be read by a member of the public. So in legal circles, you can argue till you're blue in the face, but it's much safer to simply not disclose the invention until after the patent application has been filed. One reason that academics are very resistant to this idea is that they believe that scientific journal publications are essential for their development and to bring in grant funding, and that is absolutely true. But I guarantee you I can draft and file a patent application far faster than you could ever get peer review and approval and publication of a scientific journal. So please don't let that hold you back. Okay, when should a patent application be filed? Obviously before you declare it to the public, but also as soon as you have enough information to describe how you could carry out the invention. You don't need to have actually done it, but you need to be able to describe how it could be done. And as I said before, don't worry about academic publication. You can always have a patent application filed before that could ever take place. Zantac is an example of the positive and negative power of patents. So Zantac was an ulcer drug that was marketed by Glaxo back in the 1980s, It was very successful after clinical trials and release commercially. The annual sales exceeded $2.5 billion a year. And over time, this accounted for at least half of Glaxo's annual turnover. However, when the patent expired, and bear in mind that patents expire 20 years from the date of the filing of the patent application, the generic drug manufacturers flooded the market with copycat drugs to Zantac, and Glaxo lost their market share, and as a result the company almost went under. And this is an example where a company can build everything on the back of a patent, but if they don't keep developing, keep finding new drugs, keep patenting them, when the patents run out, they lose their market share and they can potentially go under. In this case, the only reason that Glaxo didn't go under was because they entered into a collaboration with Wellcome. Okay, trademarks. Trademarks are another form of intellectual property, and as the definition points out, it's a sign or an indication of the source of goods or products or services. And trademarks serve a very important purpose. So the branding lets your consumer know what they can expect from your product. So this slide demonstrates one of the essential properties of trademarks, and that is it portrays the expectation of the consumer when identifying with a particular product or lifestyle. So on the left we have a Yugo, which was a relatively old car. It's a very, very cheap runaround. There's nothing special about it, and there's certainly no status value attached to it. And on the right is a roadster. It's a Honda S2000, which is considered to be a powerful and enjoyable car, which carries a certain status about it, a certain lifestyle indication. And the question is, which one would you rather have? And some people would instantly say that they want the sports car, that it's important to them that they're seen to be in a car that other people admire, and it's important to them. And others would say they don't want to spend a lot of money on a car. Both cars will get you from A to B. Both cars do the same essential job in keeping you safe on the roads, and they don't need to have people justify the status based on the car choice. So it's not that one brand is good and one brand is bad, it's that they show a expectation of a consumer about a lifestyle choice and a demonstration to other people on what is important to them within their lifestyle choice. So as this quote from Naomi Klein indicates, corporations may manufacture products, but what consumers buy are brands, and the brand you choose can be seen to be a judgment call on the type of lifestyle that you lead. So here's an example now of how trademarks and patents can work together to protect a company when patents expire. So in this example, Nurofen is a trade name or a trade brand for ibuprofen, which was marketed by the Boots Company plc. And ibuprofen was patented, but the patent expired in the 1980s. However, Boots did such a good branding exercise with Nurofen that when the patent expired, despite the fact that the market was flooded with generic ibuprofen drugs, the consumer still wanted to buy Nurofen rather than save money and buy the ibuprofen, because they had been converted to the brand values of Nurofen and the added value of how it was delivered. So instead of Boots losing up to 50% of their market share in this drug, in fact their share of the market continued to increase by around 16% year on year for several years after the expiry of the patent. So this shows the power of using your intellectual property portfolio to achieve something more than an individual right on its own. In this case, trademarks were used to compensate for the expiry of the patent protection. So as I said earlier, patents expire 20 years after they've been filed, and trademarks, however, they never expire. As long as you keep paying renewal fees every 10 years, that trademark or that brand can continue to be registered indefinitely, and the value of the trademark will increase over time as long as you market it correctly. But as like any other form of intellectual property protection, even trademarks have their pitfalls. So here's 3 pitfalls that are worth bearing in mind. The first one is, do you own the copyright in your logo? So for example, when you're considering your projects, if you have a graphics company design your logo and your branding for you, bear in mind that your company will not own the copyright in that branding because, as I said earlier when we were discussing the £10 note, the copyright belongs to the author. So in this case, it would belong to the designer or the design company. In order for you to ensure that you own the copyright, you would need to have what's called an assignment put in place. And this is a legal agreement which transfers the ownership of the copyright created by the graphic designer to your company. And although it's a bit of paper and it seems like a hassle, it's important because in the future, going forward, should your copyright be infringed by a competitor, the only person who can take action legally against that competitor is the owner of the copyright. And if you don't own the copyright, it would lie with your graphic designer to take that other company to court, and they are not going to want to do that. So make sure that you do all the correct paperwork trail to ensure that your company owns its own intellectual property right, and that includes the copyright. And this is the type of due diligence that an investor will be looking for when they're assessing the company with a view to putting in some funding. Secondly, have you registered your trademark? It is possible to operate a company without registration of the trademark, and in fact, when we discussed the £10 note, the Bank of England has not registered their trademark, but they're relying on their vast reputation. For a startup company, it's important that you do register your trademark because if you don't and someone copies you, you have to establish a number of things before you can successfully enforce your intellectual property right, your unregistered trademark. You have to prove that your reputation has seen damage. You have to prove that your customers were misled and thought that the goods or services came from you when they didn't. You have to prove that the competitor used your trademark without your authorization. And you have to prove that you have been financially disadvantaged by the actions of your competitor. All of these things are quite onerous and expensive to prove. However, had you registered your trademark, which only costs around £200 in the UK, it lasts for 10 years and it gives you the monopoly right to stop anyone who's using your trademark without your authorization. And this is simply a cease and desist notice sent by a solicitor or a patent attorney. And if that's ignored, it's a simple court action to achieve what you need, i.e. your competitor to stop using your mark. You don't have to prove all the things that you would have to had your mark not been registered. So think of it as an insurance policy that only costs around £200 and lasts for 10 years at a time. You can make it last longer than 10 years if you pay renewal fees, and as I said earlier, trademarks can be renewed indefinitely. Okay, finally, have you correctly marked your goods and promotional materials? And this can go very wrong if you don't get it right. So capital TM simply means that you are treating whatever expression you're using the TM with as a trademark. However, only the R in a circle means that that trademark has been registered. And the majority of people do not realise the difference. If you wrongly apply the R in a circle symbol next to your brand name or your trademark, then you could be setting yourself up for criminal prosecution, and you could be setting yourself up for a spell in prison. Copyright infringement is seen as a very serious issue, and misrepresentation of it being registered or not is seen as a very serious situation. And the reason for this dates back to copyright infringement relating to airplane parts. So there were some copyright parts on the market a while ago, a long time ago now, and they were substandard, and the planes that they were used in crashed. There was loss of life, and it came down to the fact that parts had been manufactured by competitors who had wrongly marked them as coming from a different source and therefore being of a different quality. And they decided that this was serious enough that copyright infringement could carry a custodial sentence. So just bear it in mind. Once you've registered your trademark, I'm afraid that's not the end of the story. You have to make sure that you use your mark. So failure to use your mark a few years after you've registered it could result in a third party seeking to invalidate your mark before the trademark registry. So it's important to use your mark and not allow it to lapse or be invalidated through non-use. You also need to enforce your mark. There's something called acquiescence in trademark law. And what this means is, if you're aware of a competitor who's using your mark without your authorization and you fail to enforce your mark against them to stop their actions, you are being seen to acquiesce to their use of your mark. This means that if another competitor pops up who's using your mark without your authorization, it will be much harder to stop them using the mark because you will already have acquiesced to the use of your mark by that first infringer. So anytime you see your mark being used, make sure you enforce your trademark rights. And by doing this, you can either request that the infringer stops using your mark, or you can request that they enter into a license agreement with you and they pay you for the use of your mark. And finally, keep a watch on your competitors. Just because you're not aware of someone using your mark is not a sufficiently strong argument against you having acquiesced to their use of your mark. So keep a watch on your competitors and make sure that you stop any unauthorized use of your trademark. A trademark registration is a valuable piece of property, and as such it needs to be looked after in order to maintain its value. Moving on to a third form of intellectual property, we have registered designs. Now, design right protects the outward appearance of an object during use, and that relates to the contours, the shape, the texture, the pattern, the ornamentation, anything that is relevant to the outward appearance of the object while it's being used. There's no requirement that the outward appearance is aesthetically pleasing or artistic, simply that it is not related to the actual function of the object. So one example of a registered design is the Callisto laryngoscope blade. So this is a laryngoscope blade that is used to assist with opening the airway passages in a compromised patient. And the problem with most of these devices is that when they are used to open the airways, they are pivoted against the teeth of the patient, and this can cause the teeth to break. And so this new design was registered by Tamesco in 2003, and the shape of the laryngoscope blade is what assisted it with not putting as much pressure on the teeth of the patient whilst they're trying to open the airway. Now, the actual shape could potentially have been patentable, but Tamesco decided that registered design protection was suitable for them. And in this particular example, they've protected that outward curve and shape and appearance of the object. However, for what they are protecting, it's also very important because if someone was to copy that object but change the shape, it wouldn't work in the same way. So for them, registered designs was a very effective form of protection. However, please bear in mind that for a lot of products, registered design protection is far too easy to get around. All you have to do is simply change the outward appearance, and if the outward appearance is not material to how the object is used or the effect that it has, it can be a relatively unhelpful form of intellectual property protection in some instances. And now we move on to copyright. And as I said earlier, copyright is something that belongs to the author of the right. It's automatic, you don't register it anywhere, and it protects the way something's expressed in a piece of work. So in other words, it protects something once it is fixed. So for example, that would be once a recording is fixed on a recording media, once a painting has been put to paper, something that has been recorded on video, any electronic record. It's a work that doesn't have to be artistic but is often referred to as an artistic work. So just like with trademarks, there are certain things you need to do to assert your copyright. One thing is to use the copyright statement. So this is the C in a circle symbol, followed by the date of creation, and followed by the name of the copyright owner. So in your cases, you would want to be putting the C in a circle symbol, the year 2020, and then followed by the name of your company. But bear in mind, if your website, for example, is created by a graphic design company, you will need an assignment in place, transferring the ownership of the copyright in the web pages from the graphic design company to your company. And it's important that your company owns its copyright, because only a copyright owner can take legal action against anyone infringing the copyright. So just make sure that the paperwork trail is appropriate there to give your company ownership of all of its IP. The copyright statement should be used on every page of your website. If you are authoring a book, it should be used at the beginning of the book. It should be used on all marketing material. And all it does is assert the owner of the copyright and the fact that you are aware of your rights, and thus indicates to any potential infringer that you will enforce those rights. If your product is something like photographs online, then you can use software to either prevent the download of those photographs by potential copycats, or you can tag the photographs with some software that sits behind the image, and then using other software you'll be able to detect those images if they are used on third-party websites without your authorization. And in fact, this is a technique that is used by many online photo libraries to ensure that anyone using those images on their websites have taken a license from the company. And they will enforce those rights, and rather than having to pay $5 for the image, if you use the image without authorization, they will take you to court and you'll end up paying fines of between £2,000 and £4,000. So it's definitely a point to bear in mind when you're creating your website. If your product involves some software, you could build in hidden identifiers, for example, in the form of redundant code. This means that if someone directly copies you, you will be able to prove this by identifying the same redundant code within their software, proving that they have simply cut and pasted your software code, which is protected by your copyright. And then finally, it is possible to register the date of creation. There are companies online that will help you do this. And you could put it in an envelope and send it to yourself by recorded delivery. However, this is not ideal. If you really want to assert the year of creation of your important information or copyright material, I would advise that you take it to a patent attorney or a solicitor and have them evidence it in the form of a witness statement, and they can then hold a copy of that on their files should you ever need it in court to prove the date of creation of your copyright. So as I mentioned earlier, this whole presentation was intended to demonstrate what the intellectual property rights are and how products incorporate all different forms of rights in a single product or in a range of products. And I showed that with mobile phones, and I showed it with cans of Coca-Cola, but even the humble post-it note is also one of these products. So the Humble Post-it Note has patent protection in the glue that allows you to remove the note but still stick it onto another surface without causing damage. It has trademarks in the post-it branding. It has registered design protection in the associated dispensers for the post-it notes. And then finally, there is copyright in the layout of the marketing material on the cellophane surrounding the post-it notes themselves. So even the Humble Post-it Note has all 4 forms of protection in it. I'm not aware of any trade secrets around post-it notes, but then again, if they're confidential, I don't suppose I would know about them anyway. So I hope this presentation has been helpful, and I hope that you will now be a lot more aware of the different types of intellectual property protection, how you can best use them in a company to protect your rights and protect your market share, and ultimately protect your income from encroachment by competitors. Thank you very much for your attention.